Hello everyone. Given we don't have the opportunity to sit around on the first floor at Westminster and catch up on all the developments in extradition, we thought we might helpfully use the opportunity of a quiet moment at home for a chat about all things extradition assurance in a European context. I am Louisa Collins and I'm an extradition practitioner at 5 St Andrews Hill.
And I'm Rebecca Hill and I'm also an extradition practitioner at 5 St Andrews Hill. We thought it might be helpful to look at the recent evolution of challenges to assurances by European states in respect of their prison conditions. Challenging assurances involves scrutiny of the application of the assurance to those who've been extradited. And to that extent, it is incredibly helpful if defence practitioners can keep in touch with their clients who have been removed. Although obviously that's easier said than done, given most of them don't speak English and are being remanded in custody. So it's crucial to keep up to date with political developments in the other European signatory states and be alert to helpful publications from the CPT, the Committee for Prevention of Torture, or NGOs, which might suggest assurances are no longer reliable. Lou, you've been challenging the assurance from Lithuania in exactly this way, is that right?
Yes, that's right. By way of brief background, incarceration rates in Lithuania, and this is from the Council of Europe, ranks the country at the top, with 232 people jailed per 100,000 inhabitants. That's followed by the Czech Republic with 203, Poland with 190, and Slovakia with 189. You will all, I'm sure, be familiar with the Jane assurances, which were up until very recently being issued in all Lithuanian cases. The guarantee that requested persons on an extradition warrant would be housed in one of 3 remand prisons, which was Kaunas, Lukiškės and Šiauliai, with at least 3 square metres of personal space was set out in those Jane assurances. That decision was issued in 2018 and it's now been replaced by a new assurance dated the 3rd of April of this year. And it seeks to renew the position in light of the COVID-19 pandemic and provide a more general assurance, which I'll come to in a little bit. So that position has changed.
There was a recent relevant case, wasn't there, towards the end of last year in respect of Lithuanian cases?
Yes, that was the case of Bartulis. The decision was handed down on the 20th of December 2019. So it predates the new assurance. But in that decision, the Divisional Court rejected the challenge brought in respect of the conditions in correction houses in Lithuania. Effectively, the court acknowledged that the risk of inter-prisoner violence was a real risk, but found that the authorities had made positive responses to the 2019 CPT report, and effectively those responses negated that risk. And that meant that no further or better assurance was required from Lithuania at that stage to deal with the conditions in correction houses.
Was there an attempt to certify a question in that case to the Supreme Court?
Yes, there was, but the High Court refused to certify it.
So what's the position now with Lithuania since those 2 key divisional court cases?
The position has changed. The situation has moved on quite dramatically. So as mentioned earlier, there's this new assurance that was issued earlier this month, and that is yet to be challenged and fully litigated before the courts. Significantly, one of the 3 remand prisons has closed. So as I mentioned before, there's Kaunas, Šiauliai and Lukiškės with the 3 remand prisons, and one has been closed and no new facilities being built. Prisoners have had to be reallocated from that prison. Also, the extent of the refurbishment in the prison estate has been limited and the accommodation available cannot house the number of inmates since the closure of Lukiškės. There has in addition been a Šeimas Ombudsman report that was issued towards the end of last year, in which concerns were raised that international standards couldn't be met. And finally, it appears that Mr. Guy Jane's assurance, so he himself has been breached where he was placed within the prison estate.
So are these issues being litigated or considered before Westminster or the High Court?
Yes, there's 5 linked cases before Westminster in which the position will be considered. That will include consideration of expert evidence regarding the changes in the prison estate. It's currently listed in May, but that may well be subject to change given the lockdown. I'm also raising challenges in the context of a matter at permission stage before the High Court. Becky, you've been raising similar challenges in the context of Hungary. Can you tell us about that?
Yes, absolutely. Well, practitioners are probably aware that assurances have generally been required in Hungarian cases for some time. And the terms of those assurances were challenged in a number of cases before the Divisional Court, ending in Fusesi, which was in 2018, when their lordships determined that the assurances didn't have to specify the prison in which a requested person would be held, and found that the assurances provided were adequate.
So how have you been seeking to renew the challenges to those assurances?
Well, I would like to say it was all down to me, but others have very helpfully managed to secure evidence from prisoners extradited from Germany to Hungary under protection of an assurance, in which they state that those assurances have been materially breached. There are a number of cases before the Divisional Court in which this evidence was advanced, together with updated evidence from an expert on Hungarian prison conditions, Dr. Kadar. The first of those was Szalai and Hungary, but the court ruled that the prisoner's testimony was inadmissible on the basis that there was a higher threshold for the admission as it related to an assurance that had been issued to a country other than the UK, and therefore it was much harder to assess the extent of any breaches and any underlying facts. So extradition was upheld there.
Does that mean that's the end to the challenge to Hungarian assurances then?
No, the Divisional Court in Szalai did certify a question of public importance to the Supreme Court, which has granted permission, so we're waiting for the hearing now. But the question is essentially in two parts. Firstly, where a court is assessing an assurance given to the UK, is it correct that the court should exercise very considerable caution before admitting evidence which does not relate to an alleged breach of an assurance to the UK, but relates to an alleged breach of an assurance to another state? And secondly, is it a correct approach that the court should satisfy itself that such evidence is manifestly credible, directly relevant, and of real importance for the decision in question?
Is this evidence the only way to challenge the Hungarian assurances at the minute?
Well, I'm also seeking to challenge the reliability of the assurance by reference to some recent political developments in Hungary. You will be aware of the Othman criteria, which emanates from the case of Othman in the UK and sets out the criteria which the court must consider when assessing essentially if an assurance can be trusted. One of those criteria is the availability of domestic remedy for breaches. However, there has been a political effort by the Hungarian government to revoke their compensation regime. On the 9th of January, the Hungarian Prime Minister said that it's an impossible situation that Hungary has to pay millions to convicted criminals from the money of Hungarian taxpayers because their detention was not adequate. He stated he'd instructed the Ministry of Justice not to pay a penny to inmates on that basis. And then on the 17th of January this year, he confirmed that he was directing the government to suspend compensation payments to inmates immediately. In fact, as I understand it, the changes to law have not actually manifested yet, but this approach is indicative of hostility towards human rights protections under the European Convention. And I'm exploring with the help of an expert whether this concerning momentum raises issues in respect of all of the Othman criteria. So obviously that's one political development in Europe, but we can't help but mention the other, you've already alluded to it, which is a catalyst for huge changes internationally, and that's the pandemic. Are you finding it's having any impact, positive or negative, on arguments relating to prison conditions and assurances?
Well, yes, Belgium is an example of where the pandemic has seemingly prompted a sudden reduction in the prison population. So in 2019, Belgium had the most overcrowded prisons in the EU, with 121 inmates per 100 spaces, followed by Italy with 119, France with 117, and Hungary with 115. And those conditions had led to repeated strike action by prison staff, which has aggravated the poor prison conditions, as it meant that prisoners were locked up for extended periods per day with little or no outdoor exercise. deterioration in hygiene conditions, limited visits from family members, etc. And industrial action had continued on and off for years up to and including 2019. But press reports earlier this month highlighted that there has been an outbreak of COVID-19 in Belgian prisons, including some 32 prison guards. And in response to those problems and the overcrowding problems, the authorities have made significant efforts to reduce the prison population, including implementing early release measures. So the prison population in Belgium has now dropped below 10,000 since the outbreak of the epidemic, according to the Federal Justice Ministry there. Nonetheless, the total number of people in prison still exceeds the maximum capacity. So it's at 9,870, which is above the capacity of 9,500. And it's yet to be seen whether the reduction in the prison population leads to an overall improvement in conditions, but it's certainly a step in the right direction. So, so that's the position with Belgium. Becky, are you aware of any EU countries in which the pandemic has affected the prison estate?
Well, I think the reality is that the pandemic is affecting prison estates everywhere, including here. But I am personally raising an argument in relation to Romania by reference to a number of current developments, including the pandemic. So obviously Romania has had a serious issue with its prisons for many years, which resulted in a European Court of Human Rights pilot decision against it in 2017, Resmives. In that case, the court made multiple critical findings and expressly recommended measures to reduce overcrowding and to implement a compensation regime. Our divisional court decided in a sequence of cases, Grecu, Jabaci and Varga, that extradition could take place with assurances and that the assurances were reliable and satisfactory. However, Romania has now seen a recent similar development to that I've already referred to in respect of Hungary. In December last year, the Romanian Parliament passed a law revoking provision of compensation for Article 3 breaches. And once again, this was as a result of a campaign, a populist campaign run during the presidential election, and is indicative of what may be a shift away from the European imperative of fundamental rights for all people. And this would raise concerns under the Ottoman criteria in any event, but the pandemic has heightened those fears. On the 16th of March, the Romanian president issued a decree declaring a state of emergency, and that establishes that during the emergency period, in proportion to the concrete needs, a series of fundamental rights provided for in the Constitution can be restricted. And obviously that isn't going to include limitations on the rights of freedom from torture, but it does mean a centralisation of power and restriction of civil liberties in the hands of a government who've overtly expressed their distaste for the rights of prisoners. So I'm arguing that the assurance needs to be looked at again, and each of the Ottoman criteria reassessed to see if, moving forward in the current political climate, Romanian assurances remain reliable bases upon which to extradite.
So in summary, a finding by the High Court that extradition to a country is Article 3 compliant because of an assurance that they've issued should not be considered the end of the defence challenges to return there.
Absolutely not. And in fact, it looks possible that the huge changes that coronavirus is making politically and institutionally will have significant repercussions to the status quo in terms of European prison conditions. And that will be both to the benefit and detriment of extraditees. So it's a challenging but interesting time. Thank you very much, everyone, for joining us. We hope that was helpful, and we very much look forward to seeing you in the not too distant future.
Yes, thank you very much for joining us.